We'll get on to the topic of today's session and introduce our presenters. So we're going to be looking today at the humanitarian exemptions debate. So this is with reference to the idea of humanitarian exemptions as a potential way to resolve possible conflicts between sanctions regimes established by the UN Security Council and principled humanitarian action. And we'll be exploring a number of different angles on that with the help of Naz Modirzadeh and Dustin Lewis. Naz is the founding director of the Harvard Law School program on international law and armed conflict, known as PILAC, and Dustin is senior researcher also with PILAC. So we'll be beginning with a bit of an introduction to set the frame from Naz, and then we'll get into some of the detail of the recent research on this issue presented by Dustin, and then we'll have a Q&A as mentioned with both of our guest presenters. So now Naz, I'd like to give the floor over to you.
Excellent. Thank you so much. Great. Thank you so much, Inherit. It's a real pleasure to be back with the friends from PHAP and those all around the world. I see a lot of familiar names already in the chat, and Dustin and I are really pleased to be able to discuss this topic based mostly on a recent publication of ours co-authored with our colleague Katie King. And I know that Marcus has put that in the chat, and also that you have circulated the paper to many of the registrants. And I know this is a topic of real interest to many colleagues in the humanitarian community and within the UN and sanctions communities. And so what I thought I would do is just give a bit of background to how we came to this topic, and sort of what were the issues leading us to take this issue on at PILAC and in the Counterterrorism and Humanitarian Engagement project that we run. And then I'm going to give the floor to Dustin to get into some of the substantive issues, and I'll come back at the end with some of the implications that we're seeing for this. So by way of background, we have been for some 4 years now running a project called, we call it CHE for short, or the Counterterrorism and Humanitarian Engagement Project. And in that project, we look primarily at the relationship and the intersection between global and domestic counterterrorism laws and policies and humanitarian action in situations of armed conflict. In particular, we focus on how counterterrorism laws and policies can impact or affect humanitarian action in those armed conflicts where groups designated as terrorist are a party to the conflict. And we've done briefings on this issue before with PHAP and with PHAP friends and colleagues at the advanced workshops as well. So I won't get into any of the detailed substance, but I will say that it was within that debate and within that research that we realized that there were many questions around what were some of the practical solutions that had been identified through the research for this question of the tension between counterterrorism and humanitarian action. So when we find that counterterrorism laws and policies appear to be obstructing principled humanitarian action, or perhaps even infringing on aspects of humanitarian action that are protected under international humanitarian law, what are the available solutions? And there were certainly many of them that were identified in the research that were sort of suggested or in the abstract were available. But as we continued in our research and in engaging with others who were working on this topic, I think that there was a sense that the range of available options for humanitarian actors to try to identify solutions to the tensions between counterterrorism and humanitarian action where they were present felt increasingly limited, or felt like there were some choices that would close out others. So what we began to realize is that if, for example, some humanitarian actors felt that a plausible solution to the tension counterterrorism would be to lobby for a change in the law. So to actively engage in advocacy, suggesting that domestic laws needed to be changed in order to ensure that they were not so broad as to cover humanitarian action, then that would be a choice as to how to seek a solution to this problem that might close out the option of, for example, negotiating privately with donors in order to obtain more favorable counterterrorism language or contract clauses. Or if humanitarian actors were lobbying for and engaging in advocacy for humanitarian exemptions, as we'll be talking about today, that for many there was a sense that this would close out options to, for example, actively protest and articulate critiques of counterterrorism policies and laws. So one of the stakes in this debate, as we went through the research and as we engaged with a number of colleagues in the UN, INGO, and NGO communities on the question of exemptions to counterterrorism laws and policies, was that there was a real sense that if one chooses this path, it means others are being closed out. That there is, in a sense, a fork in the road here, and that if humanitarian exemptions become the primary advocacy vehicle for the humanitarian community to seek solutions to the tension with counterterrorism, that will mean that other, perhaps better options in the eyes of some would be less available or less pursued. I think a second stake that we identified through the research and through our consultations and briefings since we published the report is that we have a sense that pursuing humanitarian exemptions as a political, legal, and advocacy matter will require the humanitarian sector to sing with one voice, if you will. That this is a request or a demand in advocacy terms that will require some show of consensus from major humanitarian players within and outside the United Nations. So if states or the Security Council are going to be convinced that they should implement exemptions to counterterrorism laws or Security Council resolutions, our research indicates that this may require humanitarian actors to be able to articulate a sense that they all agree that humanitarian exemptions are the path that should be taken. And my own sense is that where we sit right now, July 2016, we are likely quite far from that singing with one voice, and it is not clear to me that many in the humanitarian sector feel that they ought to sing with one voice on this issue. So a second stake that we identified and a second sort of background element that I wanted to make sure to emphasize before we get into the substance of the research is a sense that to decide to unify around this particular option and to expend resources to obtain some kind of consensus across the sector is a choice that will take away resources from other advocacy options and from other possible solutions. And I invite our colleagues that are joining us today to reflect as we go through this what they think about that, whether they think that this option is one that ought to command the attention of the sector and ought to urge all of us to consider whether this is an area where differences or various views on the details ought to be put aside in order to demonstrate a more unified perspective and approach to this issue. Finally, and this is the last sort of stake I'll identify before we go into the details of the research, we sense in doing this research that a sort of third conceptual stake that emerged is that in some ways where you sit informs where you stand on these questions. And what I mean by that is If your view of the humanitarian sector today is that it is representing a dialogue between equals, a dialogue between donors and grantees, a dialogue between UN humanitarian actors and their INGO partners, a dialogue between INGOs and local and national organizations, if that is your view, then you may feel that the solution to tension with counterterrorism policies is best found through dialogue, through bilateral engagement with fellow actors or with donors. If, on the other hand, your view is that the humanitarian sector today is already informed by a strong measure of top-down either control or influence from donors or from those actors like large UN agencies that are commanding major allocation of funds and resources, then you may feel much more comfortable with the idea that an exemption coming from either a government or the Security Council or a UN body is, realistically speaking, one of the only ways to solve this tension. And we'll see in the research that that perspective and that background assumption about the nature of the humanitarian sector may really inform where organizations and even individuals come out on the question of whether or not humanitarian exemptions is the preferred advocacy path or even the preferred ultimate outcome of humanitarian efforts on the issue of counterterrorism. With that, I'm going to hand it over to Dustin Lewis to talk to us a little bit about the substance of the report and some of the findings that we identified, again, along with our co-author, Katie King. Dustin?
Thanks very much, Naz, and thanks again to the PIAP team for providing us opportunity to help inform this debate on humanitarian exemptions, and at a time where I think it's really emerging as a key policy agenda item across many UN actors in the humanitarian sector in general. Over the next 10 to 15 minutes, I plan to try to do three things. The first is summarize the legal status of the UN sanctions regime. And then I'm going to turn to the two general categories of humanitarian exemptions with a focus on what we call sectoral humanitarian exemptions. And then lastly, before turning it back over to Naz, I'm going to try to explain some of the few existing and limited exemptions that have emerged at the international and domestic levels. So first, what we're talking about primarily today are the UN Security Council practice around sanctions and humanitarian exemptions thereto. The UN Security Council, of course, derives this power from the UN Charter and the authority granted to it therein in matters of international peace and security. Now, as a legal matter, those UN Security Council decisions in which the sanctions are promulgated are binding on member states. Yet, as a matter of international law, those decisions aren't usually thought to be binding or considered automatically binding of UN funds, agencies, and bodies, or NGOs, or individuals. And yet, as a matter of policy, UN funds, agencies, and bodies do consider themselves bound to comply with these resolutions, where applicable. And in order to carry out a particular decision of the Security Council, member states may consider it necessary to implement domestic measures requiring that, for instance, NGOs, individuals, and others act in conformity with the underlying obligation. It's through that domesticization process that sanctions regimes might become binding on humanitarian organizations. In our research, we found that of the various UN Security Council sanctions regimes, about 13 might implicate the work of principled humanitarian actors. Those cover areas from the DRC, Côte d'Ivoire, Sudan, Lebanon, Somalia and Eritrea, Libya, Central African Republic, Yemen, South Sudan, as well as other situations including those in which Al-Qaeda, ISIS, and their designated associates, as well as, separately, the Taliban, may be active. Indeed, under these respective sanctions regimes, associates of ISIL and Al-Qaeda, as well as the Taliban themselves, may be individuals or organizations. Now, what exactly is imposed in these UN sanctions? There's three main things to think about here, and we'll try to briefly show why they might matter, especially the first one for humanitarian organizations. With respect to each of these 13 sanctions regimes, member states are required, among other things, to ensure that their nationals and any person within their territories do not make available any funds, financial assets, or economic resources to or for the benefit of certain individuals and entities as enumerated by the Security Council. So it's here that we see with this financial resources, with these economic resource prescription, that the major potential implication might arise for humanitarian organizations. That's because these obligations have been crafted so broadly that they might fold in, at least when read literally, some of the things that humanitarian organizations do. That's because humanitarian organizations' members and leadership typically qualify as nationals or persons within the territory of UN member states, so these asset freezes could be applied in relation to them. Thus, the fees, tolls, and taxes that a humanitarian organization may deem it necessary to pay in order to access civilians in need of assistance may qualify as funds, financial assets, or economic resources. And in that case, if the authority to whom the humanitarian organization pays the fees is subject to the sanctions, then that humanitarian organization would be susceptible to punishment or other consequences under the domestic measures implemented to carry out the sanctions regimes. The other two main areas in which the Security Council legislates the types of sanctions include arms embargoes and travel bans. Yet, in certain respects, these elements of the regime seem to permit some types of activities involved in humanitarian response, or at least might be interpreted as minimizing sanctions-induced chilling effects on humanitarian organizations. For instance, some of those sanctions regimes exempt from the arms embargo non-lethal military equipment and protective clothing so long as the equipment and clothing are intended solely for humanitarian use. Moreover, while certain asset freeze provisions generally require states to prevent their nationals and persons within their territory from violating the asset freeze, travel ban provisions do not. And it's these that require states merely to take the necessary measures to prevent sanctioned individuals from entering the territory. The difference could allow states some discretion in crafting travel bans, and thus we think it's most important probably to focus less on of the three prongs of the sanctions regimes, not to focus as much on the second two, arms embargoes and travel bans, but more on the prescription or prohibition of economic resources. So what exactly do we mean when we talk about humanitarian exemptions? The first one that is most often included in a UN Security Council regime is for individuals. So here, you might think of this as the, quote, bad actor exemption, where due to the person's designation, they may need an exemption to obtain life-saving goods and services, for example, by being able to travel, which otherwise that travel might be prohibited, in order to secure some sort of medical intervention. This is not the focus of what we're talking about today. Instead, what we want to focus on is what we have designated the humanitarian exemption for the sectoral humanitarian exemption, or the, quote, good actors who constitute the entire sector, or a subset of the sector, as we'll see below, of principled humanitarian actors. This sectoral humanitarian exemption carves out a space in sanctions and counterterrorism regimes for forms of principled humanitarian action, allowing these actors to deliver their services without the risk of contravening those regimes. One example is that a sectoral type of humanitarian exemption could specify that in the case of a principled humanitarian actor engaging in a certain course of conduct and taking particular precautions in doing so, the person or the organization would not have violated the relevant UN sanctions. So again, the two major ones when we think about humanitarian exemptions, although these aren't legal terms of art, are the individual exemption and the sectoral exemption. We'll be focusing mostly on the sectoral exemption today. So what are some of the few existing and limited exemptions at the international and domestic levels? One of the most prominent exemptions arose in the context of Somalia and Eritrea in 2010. In Resolution 1916, the Security Council established what has become the only type of partial sectoral humanitarian exemptions exist under UN Security Council practice. That's to say, the decision-specific exemption. In Resolution 1916, the Security Council established that certain activities would not be subject to the Somalia and Eritrea sanctions regime. The exemption was initially limited to 1 year, but the Security Council has renewed it each time that issue has arisen. The exemption establishes that the payment of funds, other financial assets, or economic resources necessary to ensure the timely delivery of urgently needed humanitarian assistance in Somalia by the UN, its specialized agencies or programs, humanitarian organizations having observer status with the UN General Assembly that provide humanitarian assistance, or their implementing partners will not result in an asset freeze. It's important to note in this respect that this is only a partial sectoral humanitarian exemption. It's partial in the sense that it does not apply to all humanitarian actors, but only those specifically specified. It applies only under the temporal limits or the time limits bounded in the relevant Security Council resolutions, though as we've noted, these have been renewed every time that they've come up so far. And it applies geographically only with respect to the Somalia and Eritrea sanctions resolutions. So it's only for these activities that we can say that the humanitarian exemption has been promulgated by within the UN Security Council practice. At most, it's a partial sectoral humanitarian exemption. Models that rely on Security Council decisions, for exemptions that rely on them, could face difficulties since it usually requires domestic codification or whatever the equivalent might be depending on the jurisdiction. As an example, Security Council decisions have established that states establish certain terrorist acts as serious criminal offenses in domestic laws, but only some states have implemented those requirements. Moreover, the Security Council action in this area could be conceptualized as a way to help ensure states fulfill a pre-existing obligation where applicable to permit certain forms of humanitarian assistance. Here, think of the fact that many of the humanitarian access and assistance provisions within IHL could be interpreted in a way that allows the state to domesticize these Security Council mandated exemptions in a very limited way in line with IHL. In terms of the domestic models, we see a few arising. Some come from the United States and some from Australia. The one on the screen now is from Australia. These are quite limited usually, and they arise in the respect of counterterrorism regulations. The Australian model, for instance, includes within a relevant law that might otherwise restrict principled humanitarian action a sectoral humanitarian exemption. A person will not be found to have impermissibly associated with a terrorist organization or committed one of certain other criminal violations if he or she engages in conduct solely by way of or for the purpose of the provision of aid of a humanitarian nature. The two main ways that the United States and Australia and other states have adopted humanitarian exemptions at the domestic level are thus either through directly incorporating these as a legal provision by promulgating statutes or by incorporating through reference the binding humanitarian exemption within the Security Council, depending on the incorporation process for international law obligations for the state, or a state agency or regulatory body might issue guidance, which, while not necessarily having the force of law, could provide a functional equivalent to a limited humanitarian exemption. In this context, we can look to something, for instance, like the Department of the Treasury's Office of Foreign Assets Control, also known as OFAC, step to amend its regulations on Sudanese sanctions, issuing general licenses that authorize the exportation of food or medicine to certain areas. OFAC has also issued policy guidance to NGOs providing humanitarian assistance by recognizing that in a dangerous and highly unstable environment combined with urgent humanitarian need, some humanitarian assistance may unwittingly end up in the hands of members of a designated group. Such incidental benefits, however, are not a focus for OFAC sanctions enforcement. Yet, again, it's really important to emphasize that this type of humanitarian exemption does not have the force of law necessarily, but rather emerges as policy guidance. Before turning over, again, lastly to Naz, to wrap up on some of the perceived costs and benefits, we note that it's been one element of the implementation of the UN Security Council's limited partial sectoral humanitarian exemption in Somalia has been the practice of requiring the emergency relief coordinator to report on this on the implementation of that on an annual basis. And the reports of that emergency relief coordinator provide some really important indications of exactly the sort of steps that humanitarian organizations might take or might try to lay down for a broader exemption regime. One of those relates to providing certain protective measures, including things like risk management procedures. And the other one is the decision whether or not to take due diligence measures, however those might be formulated. And there's been some really important new guidance that's come out, including the NRC toolkit in relation to counterterrorism measures that might provide some really important grist for the mill here. So with that, I'll turn it back over to Naz to wrap up the discussion on the perceived benefits and costs of certain suggested humanitarian exemptions.
Thank you very much, Dustin. As Dustin suggested, I'll just very briefly reflect on some of the perceived costs and benefits of these approaches, particularly as we heard as we identified during the research, but also as we heard from colleagues on the donor side, on the counterterrorism side, and on the humanitarian side as we were working on this issue and putting together the report. The first is the sense that I think there is a real perception of risk here in the minds of some humanitarian actors. There is a sense that going down the road of advocating for exemptions, going down the road of advocating with the Security Council to try to seek either an omnibus across-the-board exemption or individual exemptions cooked into individual sanctions regimes is a dangerous move for a number of reasons. I think the most significant one we've heard is that it risks actually limiting the authorized humanitarian activities. So in a sense, if you imagine that this really rather stunning icon in front of you is acting as a funnel but also as a gatekeeper in such a way that asking for exemptions, the very act of going to the Security Council or going to a domestic legislative or governmental body and saying, we, the humanitarian sector, are asking that you exempt what we do from this criminal law or sanctions regime that would otherwise potentially regulate that thing that we do, that act invites those legislators to limit what is considered humanitarian, what is considered, quote, legitimate, and what is considered lawful. And if you look closely at this icon, you will see that one of them, medical care, is actually crossed out. What is another risk that may be perceived here, and indeed may be a reasonable concern, is that in doing this limiting, what if those legislators actually say, wait a minute, why are we authorizing medical humanitarian actors to provide life-saving care to terrorists? Let's stop that. Let's not allow that. So sure, we'll carve in an extension, but in so doing, we will actually leave out humanitarian activities that are otherwise authorized by IHL. We know this can happen because we know that there are criminal laws that criminalize actions which are not unlawful under international humanitarian law. So we know that this is possible. And certainly one concern about the very act of lobbying for exemptions is that the response may be, oh, thank you very much for asking, yes, but now we're going to actually limit what we consider to be humanitarian and what we consider to be legitimate. And certainly I think all of us can understand that in the current geopolitical environment and with the seemingly ever-increasing global concern regarding ISIS and its quote-unquote soldiers around the world, there is a sense that there could be many governments, donors, or regional authorities who could articulate a reason why certain humanitarian activities ought to be limited or even cut off in areas controlled by a group such as ISIS. And of course, we've most notably seen this in the actions of the government of Syria, but I by no means think that it would be limited to such a government. The second concern about exemptions, and this is coming from an entirely different side. So if the first concern is from the humanitarian sector and is a concern that says, in essence, if you forgive me for slide switching, I'm going to go back to that. This concern says, in essence, we have more space to maneuver above the funnel. We have IHL, we have bilateral negotiations, and we have the flexibility that comes with an ambiguous rule structure. And once you start asking, you will end up with less space than you had. Right? The next concern comes from counterterrorism authorities and governments. And this concern is that exemptions create a loophole. That existing criminal laws and existing sanctions mechanisms are purposely without exemptions. And the reason they are purposely without exemptions is the concern that if you were to begin to articulate specific domains that are authorized to provide some kind of material, resources, support, or goods to designated organizations, that you would allow terrorists to take advantage of those exemptions for purposes of getting more resources to terrorists. So let me give a concrete example. Some are concerned that if, for example, the Security Council were to have an omnibus resolution carving out humanitarian activity from all sanctions mechanisms, including all the counterterrorism-related Security Council resolutions, that a terrorist group would, for example, then support illicitly a so-called charity or humanitarian organization in order to drive the flow of resources to its fellow comrades in arms in other countries or other places. This concern is sometimes called the fungibility concern, but I would say that in the domain of exemptions, it's much bigger than fungibility. It's not just the question of whether terrorists can manipulate resources for different purposes, but it's also a question of whether exemptions as such pose a security risk because they invite the manipulation of the exemption for purposes of channeling resources to terrorists. Now, one response, and I want to be very clear here that we are simply presenting different perceptions and views that we have heard. We are not ourselves, of course, supporting or advocating for any of these views, although I'm happy in the Q&A to give our own evaluative sense of some of these concepts. One possible response to both the humanitarian concern about limitation as well as the government or counterterrorism concern about loopholes is certification. So what if there were some kind of entity that were to say, this organization doing this work, either at an organizational level or at a specific conflict-based or country-based level, is indeed getting the stamp of humanitarian approval. This is a real humanitarian organization. Now, we are very, very well aware that the certification debate is a long one. I know there are many colleagues around the world who are already sighing and thinking, oh, not again with the certification debate. But my sense is we are going to see a revival of that debate if this exemptions idea goes forward. Meaning, I think you cannot, practically speaking, have exemptions at the Security Council level unless you are also willing to entertain the idea of some kind of gatekeeper or certification or verification process. And I think the question becomes, Does the humanitarian sector want that to be a self-regulatory move, meaning the humanitarian community generates its own proposals for certification, or if we feel that certification goes against the very spirit of humanitarianism, are we willing to take the risk that that process would be articulated and managed by donors or other governmental authorities? And I think in some ways that is sort of the next phase of this debate may be one about what the practical elements of this look like. And Herod, with that, I'll turn it back over to you. And I know you have a number of questions that have come in already, so we'll be very delighted to take those. Over to you.
Okay, terrific. Thanks so much to both of you. Excellent presentation as usual. Great to have you with us on this issue that I know is of significant concern to so many people around the world in our network. So we do have a number of questions that have come in. I'll go first to a question from Julian, based in the US. And forgive me, it's a bit long, but I'll read it here verbatim and then hand it over to the two of you. And you can sort out between yourselves who would like to come in first, if you don't mind. So from Julian, he writes, I was wondering if advocating for UN exemptions would really reduce or result in a significant reduce in a significant manner bilateral discussions with donors, knowing that if we're talking about exemptions in UN sanctions regimes, a key question will be the domestic implementation of these exemptions, which is likely to require bilateral discussions and arrangements, as we see today with the practical implementation of various licenses. Maybe that would move discussions from the field to DC, Paris, Brussels, or London, but don't you think that discussions on the domestication, or practical implementation of potential UN exemptions would be necessary? Over to you.
Thanks very much, and this is Naz. I'll take that. I guess I don't need to really distinguish between my voice and Dustin's. Great question, and here I suppose I'll betray a bit of my personal view. I tend to agree very much with Julian. I think that sometimes there is a false assumption that Security Council resolutions are the end of the process, that if you were to obtain an exemption, that is kind of a top-down process that once completed would simply sort of be a decision to go with a top-down process. And indeed, I think in reality, what we see and what we saw with the Somalia exemption starting with 1916 was that there is a tremendous amount of bilateral follow-up, that many states, in fact, do not take the steps required to implement these exemptions in their domestic law. Indeed, the United States did not take the steps to implement the 1916 exemption in its own law, and to this day has not clarified how the Security Council resolution aligns with its domestic material support statute. And the U.S. is certainly not alone in that. So I think this question raises a tough challenge. Are humanitarian organizations prepared to take on what we consider to be a significant political advocacy and research task? And that is not simply the decision about whether or not exemptions ought to be advocated for and whether or not they are a good solution to this problem, which is, as I've indicated, I think something that is there are different opinions about. But second, if yes, then is the humanitarian sector prepared and equipped to do the follow-up work, the negotiations at the bilateral level, pursuing domestic law that would implement whatever exemptions occur at the Security Council level? And third, raising awareness and educating governments about the implications of exemptions and why they may be important. We have certainly found in our own research and engagements that many government actors and certainly many counterterrorism officials really may not know why an exemption could be useful for humanitarian actors. They may not be aware of the kind of work humanitarian actors are doing, and that there are indeed significant legal protections for some of that work in IHL and elsewhere. So again, just to close up, really important question. I think it's a great point. I tend to agree very much that this is not a black and white choice between ongoing bilateral negotiation or kind of multilateral advocacy, but rather that a successful approach, if one wants exemptions, will combine both strategies and efforts. Over to you, Anherd.
Terrific. Thanks so much, Naz. I'll go now to a question that's come in from Kay. Kay's asking, are states required to respect Security Council exemptions, even if just refraining from enforcement of domestic restrictions that are contrary to the UN exemption? Back to you.
Thanks, Anherd, and thanks, Kay. This is Dustin, although, again, probably don't need to distinguish between Naz and my voices here. The short answer is that the question of whether a state needs to adhere to the obligation entailed in the Security Council decision is separate from any of the domestic arrangements concerning that state's domestic legislative system and enforcement mechanisms. So through Article 25 of the UN Charter, all states are required to carry out decisions of the Security Council. And of all of the 13 sanctions regimes that we focused on in our report were decided pursuant to the Security Council's authority vested in the Security Council by all member states in Article 25 of the UN Charter, and thus, at least under international law, failure to carry out the decision, including where necessary by implementing it and taking the relevant steps at the domestic level, would put that state in a position of non-compliance vis-a-vis the Security Council. This, of course, can create some peculiar contortions from a practical perspective where the United States, for instance, has not given effect in its domestic law to the Security Council imposed obligation entailed in Resolution 1916 concerning the limited partial sectoral humanitarian exemption with respect to Somalia and Eritrea. So that is a somewhat long-winded way to say that, yes, technically it does not matter as a matter of international law. The obligation is there irrespective of whether or not the state implements it. It's whether the state would then, within international law, be considered to be acting contrary to or contravening that obligation imposed by the Security Council.
Great, thanks so much. We have another question coming in from Robin, yes, as my colleague Marcus just mentioned in the chat, in case you prefer that I not mention your name when posing your question, not a problem at all. Just let us know in the text of your question, and we'll take note of that. So Robin asks or writes, I'm really surprised that activities endorsed by IHL could just be legislated away, particularly by a state party to the Geneva Conventions. Is this really the case? Has any state tried to prosecute activity considered legitimate under IHL? And further writes, I'm assuming that those aspects of IHL that constitute customary law can't simply be legislated away. Dustin, this may be a question right back to you.
Excellent. Thanks very much, Anherd, and thanks, Robin. So there's a few things to disentangle here. One is what the relative level of authority of obligation is under international law, and with respect to what obligation here. Another is the domestic implementation of the underlying international law obligation. And then two would be if there does arise a conflict of norms between the different obligations, trying to decide what rule or what principle or set of principles you would resort to in order to discern which of those rules, which of those obligations trumps the other obligation. So with respect to medical care, for instance, we've seen in certain contexts such as Syria, Peru, and the United States that certain medical caregivers have been prosecuted, or in the case of Syria, actually targeted for a direct attack, it seems, as well as detained indefinitely, for providing medical care and assistance to quote-unquote designated terrorists. Whether or not IHL provides protection for these individuals is a matter of interpreting, discerning what the status is of the relevant treaty provisions and customary national law norms. We, at some length in a report last fall, tried to shed some light on the difficulties in identifying exactly the scope of some of those treaty provisions and their customary analogs under international law, and whether or not they would protect all of them. Needless to say, the states have undertaken these domestic prosecutions for medical care providers that at least some people would say for some of them are covered by IHL, although I do think there is a legitimate question, at least with respect to some of them, especially people attempting to travel abroad to provide medical care in areas subject to the control of a designated terrorist organization. Another element here to consider is where the Security Council has imposed a sanction, what that relationship would be with the relevant treaty provision of IHL versus the relevant customary national law norm. Very quickly, I'll just mention that we uncovered that 2 Security Council sanctioned individuals under the Al-Qaeda and ISIS terrorist designations, as well as 2 organizations associated with Al-Qaeda, were listed by the Security Council sanctions body in part for having engaged in medically related activities alongside of the enumerated list of things that they've done that were more generally considered to be encompassed within international or domestic law definitions of terrorism, such as direct bombings directed at civilians. I bring this up because it lays bare the question of what the obligation, what the priority of obligation would be between this imposing this UN Security Council sanctions regime against those 4 things, 2 people and 2 organizations, when it comes to an economic embargo, to the travel ban, etc. Versus the IHL norm, whether or not it's a treaty norm. It would seem as if it's only a treaty norm, then by operation of Article 103 of the Charter, that the Security Council imposed obligation would likely be seen to trump. Whereas if it's a jus cogens so-called norm, then I think it raises a much more difficult question of international law to figure out how best to resolve that question. So the upshot is that this is an area where we have been concerned that states may be eroding foundational IHL norms by implementing sanctions and sanctions regimes and accompanying criminal prosecutions for things like medical care. And we're very hopeful that more discussion will occur on these topics.
Okay. Excellent. Thanks a lot, Dustin. We have a question now I'd like to bring in from Elvira, and this is regarding the issue of certification, briefly mentioned by Naz in the little wrap-up bit after Dustin's presentation. So on the issue of certification, Elvira is asking, aren't organizations who are receiving funds from donors already going through certification-like processes? So whether it's called registration, organizational assessment, annual evaluations, due diligence, etc., what would be different if we're speaking about something that's, quote, certification compared with what's already happening? Over to you, Naz.
Yeah, great question, Elvira. And I think, so on the one hand, I don't know, and on the other hand, I have an intuition. I think that the difference is that we would be talking about some kind of a globally coordinated certification that would have the buy-in of the major donors and possibly even intergovernmental bodies such as the UN. Meaning, if what you want is to create the grounds to be able to negotiate an exemption at the Security Council level, and I should note here, by the way, there is a UN high-level review on sanctions that calls for exemptions, and there is also some really interesting language about humanitarian assistance, although not mentioning exemptions explicitly, in the recently agreed resolution on the global counterterrorism strategy at the General Assembly. So if there were a concerted effort to go for exemptions at the Security Council level, and if you think that that might involve some kind of a vetting or certification mechanism, I think the difference with what Elvira is talking about, the various registration, regulations, authorization for who counts as a charity, tax status, etc., is that this would have to be something that at the global level all the major players would say, we agree that this is an acceptable mechanism for determining who is and is not a humanitarian organization for purposes of the exemption. And of course, just to be very clear about what the alternative view is, the alternative view may be one that says the spirit of humanitarianism is not one that is about professional certifications or about some authorized entity telling us who is and is not humanitarian, that was never meant to be what it was to be a humanitarian, and that it unnecessarily and inappropriately narrows the field down to those who have the resources required to make it through the gauntlet of this certification process. Back over to you.
Excellent. Thanks a lot, Naz. So here's a question from Anna, based in the UK, asking the following. So, cash programming or cash transfers are increasingly common in aid, with an emphasis on engaging more and more local partners to empower and support local actors in their relief efforts at times of crisis. Could you comment on the impact of sanctions regimes on banking regulations, which can impact INGOs' ability to transfer funds to local actors, thinking in particular of the Syria case, but also potentially others? Over to you.
Yeah, excellent. Two responses. One, there's a great HPG paper on the question of the impact of banking regulations specifically on the NGO sector in the UK, and also an excellent Oxfam Adesso report on the impact of the private sector and the banking sector's increasingly risk-averse mentality informed by counterterrorism regulations and the impact on the Somalia crisis. What I will say here is there is an increasing mountain of evidence that suggests that the private sector, and particularly the financial sector, has responded to domestic and international counterterrorism regulations by doing what is rational for a profit-seeking private actor, which is to say any accounts and any services that pose a high risk in the language of counterterrorism and a low reward in the language of profit is not a worthwhile service for us to offer. And because these are private entities, they of course can simply cease those financial services. No one has a right to bank. So if a bank simply decides that they do not find it worthwhile in their own risk assessment to continue to provide services to humanitarian organizations or UN entities, they can do one of two things. One is to de-bank or de-risk, which is to simply cut off the service, and the second is to increase fees on those services such that a far greater proportion of the humanitarian funds are going to banks instead of to their ultimate end users. So this is a really important and significant issue. There's some excellent work being done, again, HPG, Oxfam, and others, thinking through the implications of some of these issues. And I think there is a sense amongst some donors that this may actually be an area where governments can help the humanitarian sector in trying to engage in a dialogue with private actors. On the cash assistance issue in particular, I would draw the attention of the audience to the recent World Humanitarian Summit, and something that we found to be a bit curious. Many had the sense that the emphasis on cash-based assistance was one of the few real success stories of consensus at the WHS, an area where all those in attendance seemed to agree, yes, this is an important innovation and something we should support. What I found surprising is not that that was the case. Whether or not one thinks that cash-based assistance is the way to go is, of course, an important and separate question. But what was surprising was there was no mention of counterterrorism regulations. when in fact, in areas where designated groups are active, so just a short and incomplete list, Somalia, Yemen, Gaza OPT, or so Gaza West Bank at the very least, Afghanistan, Iraq, Syria, just to name a few, in those areas, cash is, of course, the single highest risk humanitarian good in terms of diversion to designated groups. And so I wonder if donors' insistence upon or celebration of cash-based assistance as preferable might provide an opportunity for the humanitarian sector to say, we hear you saying with one voice, cash-based assistance. And yet we hear another part of your government saying increased counterterrorism restrictions and regulations. We are asking you, if this is how you want aid to be provided, tell us how that works and clarify for us how that does not put us and expose us to greater risk as to counterterrorism restrictions. And perhaps one answer is exemptions. I don't know that it solves all of the potential dilemmas that arise with cash-based assistance in places where groups like ISIS, the Taliban, or Hamas, as to some donors, are active, but at least it provides a really specific grounds on which to have the discussion and the dialogue with donors and regulators. Back over to you.
Great. Thanks a lot, Naz. So we're rapidly nearing the end of our hour now, so we'll be wrapping up the events. I will ask both Dustin and Naz if they have any closing thoughts for us. But before I do, I'll just mention we will be gathering up all of the resources. I see a lot of links to great resources on the left-hand side here. So we'll be gathering all of those up, adding them to the recommended resources that we already have, and making those available together with the link to the recording, and you'll get that information by email. But now, just for a brief closing remark to Dustin and then to Naz, if you have any thoughts to leave us with regarding perhaps where your own research is headed in related directions, or perhaps some new issues that you see that might be on the horizon that humanitarian practitioners and other stakeholders might want to be aware of and look out for. So over to you first, Dustin.
Excellent. Thanks very much, Anherit, and thanks again to the entire PIAP team and for everybody for joining us today. I'll mention two things quickly. The first is that I think there's going to be a strong push in this area, and we're trying to respond within our research to obtaining evidence at a quantitative, in addition to qualitative level, of the potential impact of things like sanctions and other counterterrorism and counterterrorism regulations on principled humanitarian action. So I think that this will be an area of increasing importance within the policy discussions and within legal context. And the second thing I'd like to emphasize is the focus on UN Security Council practice here requires, I think, a level of nuance here, given that the Security Council is an inherently political body and that the different sanctions regimes often arise in very different contexts, such that the approach of potentially pursuing a omnibus or all-purpose resolution might present particularly unique challenges with respect to humanitarian action assistance, given the breadth and diversity of areas where humanitarian action occurs. So I think that there's a call for sort of thoughtful reflection on how exactly these sanctions regimes are occurring within the UN Security Council context, and whether or not it makes sense to really appeal at that body level or more at the domestic implementation or regional implementation level in order to help ensure that principled humanitarian action can continue as it's meant to. And I'll turn it over to Naz for her concluding remarks.
Thanks very much. I'd certainly emphasize what Dustin just said about, so I think there's a move to thinking about evidence and data on this question, that sort of have we reached the stage where in talking about this question, we need to say more than simply there is an impact or there is a tension, and be able to in some way quantify that impact. Second, I would say I think there's a new energy on this question of financial regulations in the private sector. And I would draw your attention to the work of the Charity and Security Network on the recent redrafting of the Financial Action Task Force Recommendation 8, which relates to the nonprofit sector. And here I'll just make a pitch, if you allow me, to say I think that doing work on these issues may involve asking some within the humanitarian sector to gain expertise and fluency in areas that may seem quite foreign and indeed in some cases may seem quite boring. The Financial Action Task Force work is quite different from the work of most in the humanitarian sector, and indeed much of their work does not directly relate to humanitarianism. And yet I think for the humanitarian sector to be able to advocate for its positions and its perspective effectively in the coming years as counterterrorism efforts at the global and domestic sectors become more robust and arguably more restrictive in light of the perceived threat from ISIS and other groups will require some within the humanitarian sector to have the ability to engage counterterrorism officials and financial regulators from a position of expertise and fluency in the vocabulary and language of these fields. I'm certainly not suggesting that they lose the humanitarian perspective, but rather that the needs for advocates that are able to engage these disciplines and these professional communities may change and shift in the coming years. And I think that the exemptions debate may be interesting in the way that it presents the humanitarian sector with an opportunity to reflect not only on what are the best solutions to this dilemma and how ought they be pursued, but also what kind of language and expertise should advocates have in engaging on these issues. Back over to you, Ann-Herod.
Great. Thanks so much, Naz. Thanks to both of you, Dustin Lewis and Naz Modirzadeh, and colleagues at the Harvard Law School Program on International Law and Armed Conflict. It's been a pleasure having you with us today, and we look forward to the next expert briefing together with you. To our participants today, please do let us know either in the survey that will pop up when we close the event or separately by email if there are other issues that you'd like to see addressed in this kind of virtual venue. Or perhaps existing new research that would be interesting, useful to explore in this kind of venue. We'd be very happy to hear from you and to pick that up. I'd like to thank the team here at PHAP, Saranjana Das, Liz Arnanz, and Marcus Forsberg for all their hard work here behind the scenes. And then finally, until next time, this is Ann-Herod Lang signing off from Geneva. Thank you very much and looking forward to speaking with you soon.